We are back here this afternoon to begin the Rule 19 oral argument. BR versus the West Virginia Department of Health and Human Resources, Bureau for Children and Families Child Protective Services, docket number 18-1141, an appeal from the Circuit Court of Kanawha County. And although Justice Workman is not here in the courtroom today, she is viewing and listening, and she will be participating in the decision and opinion in this case. I'll remind counsel that you each have 10 minutes to present your oral argument to the case, and you may proceed to counsel table, and counsel for petitioner may put on the microphone cover and begin. Thank you.
Are you getting ready? I'll just go ahead and repeat. We are practicing social distancing here and have barriers between us, so I invite the members of the court to remove their masks during the questioning, and you can as well while you're speaking. You certainly may remove your mask while you're speaking.
All right. Thank you, Your Honor. May it please the court. The central issue we have in this case is whether there is any doctrine at all that supports the claims of the appellant in this instance. What we're going with our argument is that based on the doctrine of parens patriae, the state, including the executive branch, has a duty for the protection of certain people, in this particular instance, the protection of children. Now, this doctrine has been found to apply to anybody who's considered to be vulnerable. It could include the elderly, it could include children, anybody who could be considered to be vulnerable. And based on what we've asserted in our complaint, there are a number of factual assertions that we have made that clearly support that this duty has been violated. Now certainly there is a qualified immunity doctrine that would preclude some claims against the state, but at the same time, our belief is that based on these claims that we have asserted that there is a clear duty that has clearly been violated in this instance. We think that based on this, based on the egregious facts of these circumstances, that our client has a right to make a claim against the state of West Virginia. Now, this case was previously filed, and it was dismissed based on a Rule 12b-6. As a result of that, and as a result of this court previously ruling, we went and we refiled. Now, there have been several claims that have been made against the resubmission of this petition that we have filed. There have been legal doctrines such as res judicata and collateral estoppel and the role of the case doctrine that are asserted to attempt to preclude this claim. Now, if you look at all those doctrines, one thing that they have in common is that the case, the previous case, has been heard on the merits. This case never proceeded, whether in the previously filed case or the current one, it never proceeded to the point where there was any kind of adjudication and hearing on the merits. There was
you sound like, again, from your outset, you're putting most of your eggs in the parens patriae basket, but you haven't mentioned yet that on the refiling, you allege a specific statutory violation. Isn't that where the weight of your argument rests, that on the refiling, you cite a specific statutory code that had not been referenced, and therefore, rather than what you suggest is your primary focus, isn't the better focus on that you are alleging a violation of a statute?
We are alleging that as well, Your Honor, yes. And with that particular statute, we think there's been a clear violation as well of the statute, and I think we've properly pleaded this case to assert this. That being said, I think if you look at the facts in this particular case, all of those facts that we have asserted relate to, from our position, they relate to both the statutory provision and the doctrine that has been asserted as well. And we think that, I mean, if you look at the dismissal order from Kanawha County, the more recent dismissal order, it's very clear based on that order that there really isn't much dedication made to it really doing any kind of proper assessment of the various claims that are in the amended complaint. And that's one of our issues. I mean, we're not necessarily asserting that this, well, we certainly believe in the case, and once this thing is back, we believe that it can and should go to a jury trial. But at a minimum, there needs to be more analysis done on the specific elements of why the statute does or does not apply, or why the legal doctrine that's asserted there does or does not apply. There needs to be more than what's actually asserted in the dismissal order.
Counsel, in the Crouch versus Gillespie case in 2018, this court addressed a similar issue, not entirely specifically the same as what we have here, but the court there found that there was qualified immunity because there was, when you're talking about an investigation, that you know, there has to be some leeway on the part of the agency as to how they conduct that investigation. So how would you distinguish the current case from the decision, if you're familiar with Crouch versus Gillespie?
What I would distinguish between the two is I think that based on the statutory law and how the complaint was worded, I mean, I think it's clear that there at a minimum has to be some sort of investigation. And I believe that if you look at our particular case and the facts we've asserted, there's been no investigation whatsoever. Okay, and I think that if you look at that, and if you look at how the complaint is worded, we think it's entirely appropriate for this case to go back to the circuit court and to make some determinations on that. I mean, we don't believe that was even done in the dismissal order whatsoever.
Isn't the distinguishing factor between Crouch and the current case is that in Crouch it was a policy, not a statute, that was alleged to have been violated, but in this case it's a statutory? Isn't that the big distinction?
It is a distinction, yes, Your Honor. I believe so, and I think that perhaps is the largest distinction. So, and essentially, Your Honors, I believe that if this case goes back, the court can hear this case on the merits, and we believe that based on everything that was presented in our amended complaint, that it's entirely appropriate for this case to be sent back to the circuit court and for the circuit court to take a look at this again.
All right. Thank you. The respondents.
May it please the court, my name is Julie Meeks-Greco. I'm here on behalf of the West Virginia Department of Health and Human Resources and the agencies underneath that umbrella. We're here today on what we believe to be a very narrow issue, and that is whether the 2018 Circuit Court's decision granting our motion for summary judgment is proper given the previous ruling of this court in BR1, and we believe that it is. BR1 considered the complaint, which is virtually the same complaint that was filed in 2018 with very few differences other than the citation of the statute in reference to the doctrine of parens patriae. BR1 looked at the sufficiency of the pleading and determined that with the facts pled, which are the same operative facts we have in the complaint that was dismissed most recently, that the plaintiff failed to establish any facts that would support that the DHHR was not entitled to qualified immunity. And we believe that once that case was appealed to the Supreme Court and the Supreme Court issued its ruling making those findings and did not remand the case to the Circuit Court for additional pleading and in fact found that no additional pleading was necessary, that became the adjudication on the merits, and this claim therefore should be barred by the doctrine of res judicata and collateral estoppel, because we do have the same parties. We have
How do you get to res judicata and collateral estoppel when the first dismissal order explicitly stated that it was without prejudice?
I'm sorry, ma'am.
How do you get to res judicata or collateral estoppel when the first dismissal order was fairly clear that it was dismissing without prejudice?
Well, because that was appealed, and this court made the finding that the dismissal without prejudice was correct, and this court determined that no further pleading was required, and that plaintiff had the opportunity to make her best case, and that the respondent was entitled to qualified immunity. The facts are the same, the parties are the same. Once this court made its decision and did not remand it for further pleading, that addressed the merits of the case, and that became a final order. A 12b-6 can be a final order unless it's specifically without prejudice. While that order was without prejudice, this court determined that no further pleading was necessary and upheld the original order issued by the...
Upheld the original order without prejudice.
Correct.
And which the circuit court was essentially saying, you got no claim based on what's here, go try again if you want to. They're thus without prejudice, right?
The circuit court did do that, and
Yeah.
plaintiff did not do that,
the
but brought it on
plaintiff
appeal.
has gone one extra step in its most recent one, in fact, in that it has alleged a specific violation of statute which was not addressed in the most recent dismissal order. Is that correct?
It was addressed more in a footnote in which the court said this is simply a way to get around qualified immunity, and frankly this is essentially the same facts as the Crouch versus Gillespie case. While Gillespie addressed policy, the policy follows the statute, and this statute is riddled with discretion. The acts of the DHHR in responding to any report is discretionary, and in applying its discretion, they made whatever.
Wouldn't it have been nice if the circuit judge would have gone through that analysis and told everybody that his belief was, despite the fact that they added a count which alleged a violation of statute as their basis for getting around qualified immunity, wouldn't it have been nice if the circuit judge would have given us more than a footnote to tell us what he was doing?
I think that it would have been clearer, but I don't think it's I don't think it's fatal to our position. The facts are exactly the same, with the exception of the reference to, well, the facts remain the same. The reference to the clearly established law is a statute that is discretionary and implies discretion and imbues the DHHR with the authority to exercise its discretion on behalf of children. And while the court did not explicitly address that, it did note that it was bound by this court's finding that the DHHR is entitled to qualified immunity under the facts asserted, and that assertion of the statute did not specify the clearly established law that the DHHR violated with the facts as pled.
So help me understand how 49-2802 is discretionary when I think it seems clear that there needs to be a face-to-face interview with the child or children within 14 days. Did I mishear it? Are you arguing that that is a discretionary?
I think that where the discretion comes in is from the moment a report comes in, there would be a determination of whether that report satisfied the definition of abuse and neglect, and therefore would be prompting what action to take. So with the facts as pled, it is not clear that any report specifically came in alleging any facts that state who did what to whom and how that was violated. What we have is a reference to the statute, and then the petitioner asserting that the DHHR did not do a thorough investigation, which is Crouch versus Gillespie and has been decided by this court.
So you're looking at the statute, each local CPS office shall, upon notification of suspected child abuse or neglect, commence an investigation. So what you just said of who or what or when, you're saying that there was, your suggestion that there was not sufficient notification of suspected child abuse.
What I'm saying is that the facts pled in the complaint do not establish facts that would show that that statute was invoked and violated. It simply says a plethora of calls were made regarding.
What do you think satisfies upon notification of suspected child abuse or neglect? What do you think by the statute would trigger that obligation for the CPS to investigate?
I think what CPS is charged with is protecting children in certain situations. So if a call came in saying this child has been assaulted by this family member or this custodial person, and they were abused in this way at this time, that would be sufficient.
It's a pretty high bar, don't you think?
I think it's discretionary, and the DHHR has policies in place to determine that, but it is all discretionary, as it has to be, because it's not ministerial, and there is no check-the-box way to really address a situation where calls come in, and the facts will always be different. Discretion is necessary, and
Has there been any discovery at all in this case?
I apologize.
Has there been any discovery at all in this case?
In the 2016 case, we had served discovery, and the petitioner had answered that discovery.
And did that discovery indicate that there was an allegation that the custodial individual, I guess it was a relative, did it specifically lay out what the allegations were?
I don't recall specifically if all of that information was in there.
Well, let me ask this. Let me ask the question in a different way. Does discovery reveal what was stated to DHHR whenever the first call was made?
I do not believe so. And I will say
that would be an interesting fact to know, wouldn't it? I didn't mean to put you on the spot. Yeah, I did. I actually did mean to put you on the spot. I'm sorry. But that would be an interesting fact. And we're back here at a 12B6, and so essentially notice pleading, and there's been essentially no discovery in this case. Shouldn't this case go back and let there be a little bit of discovery and then make a decision once at the summary judgment level?
I don't think so, because I think that when we did do the discovery, plaintiff had the opportunity to identify what clearly established law was violated, failed to do so in the 2016 complaint, failed to do so in response or in her appellate, her appeal initially, and has failed to plead those things specifically now. And the court noted that she had those failures in her pleading and had pled, and stated, it is clear the plaintiff, the petitioner, has pled her best case. No further pleading is required.
It's a little bit unclear from the record, but was there ever a face-to-face interview with the child? I know there's a question about the 14 days, but does the record reflect whether there was ever an interview with the child?
That is not part of the record, but yes.
All right. I believe your time has expired, so we thank you for your argument. And have any brief rebuttal from the petitioner?
That's okay.
That's okay.
May it please the court, just a very brief rebuttal to this. Based on the complaint that we have here, it's just based on paragraph 9, and I would direct the court to that. The plaintiff reported to DHHR the abuse she sustained as a result of her aunt and uncle, yet the defendant did nothing. The defendant, DHHR employees and its employees did nothing after independent, credible sources made numerous reports. So from our perspective, it was pled that there were actual legitimate reports that were made to DHHR, and we have pled that. With regards to discovery, from our point of view, the discovery really didn't get going to the extent that we thought it should have. I know it's not part of the record in front of this court, but we really didn't get a chance to get much into the discovery to actually, we believe that the discovery that we did receive was insufficient, and we think that with further discovery, that would have supported the claim. So it was very, very early on in this process when we actually received the discovery. It was actually I believe the first hearing that we had, or at least the second hearing that we had, was the motion to dismiss at that point, and we didn't get very far into discovery whatsoever.
All right.
Nothing further.
All right. Thank you very much. This case will be submitted.
Thank you.
The next case for oral argument this afternoon is also under Rule 19, In Re MM, HM, and WM, docket number 190926, an appeal from the Circuit Court of Randolph County. And I will let you know that although Justice Workman is not present in the courtroom here today, she is viewing and listening, and she will be participating in the decision and opinion in this case. I'll remind you that each side has 10 minutes to present your oral argument, and the respondents need to split that 10 minutes. Counsel for the petitioner may proceed.
Good afternoon, Mr. Chief Justice, Associate Justices. May it please the Court. I'm Brent Easton. I'm here on behalf of the petitioner in this matter, the mother in the lower court, MM. The lower court abuses discretion by finding that the petitioner failed to successfully complete a post-adjudicatory improvement period after the respondent, DHHR, suddenly discontinued payment for Suboxone treatment via a special medical card issued by the department specifically for that purpose. The petitioner came to this case basically with a single issue of neglect, and that was that she was a drug addict. Otherwise, MM maintained employment, provided housing for the child IM, provided nourishment, provided financially, maintained her own transportation, even regularly attended church. In fact, this court granted the circuit judge's recusal based on the fact that he went to church with MM. On October 2nd, 2018, MM stipulated to the neglect by way of admitting that she was a drug addict who engaged in that activity while in the care of the child IM. I'll note that the other two children at the time resided, one in Washington, Pennsylvania with a relative, and then the oldest child, who at this point was a teenager, resided with the maternal grandparents, also in Randolph County. A term of the improvement period included that she enter a, quote, in-state sobriety treatment program approved by the MDT. end quote. And the program that was approved by the MDT and ratified by accepting the terms of the improvement period by the court was that she entered the Clarksburg Treatment Center, which is a Suboxone treatment facility in Harrison County. DHHR, specifically at the time this improvement period was implemented, provided the petitioner with a special medical card to pay for the Suboxone treatment. And this was because through her employment, she made, although she wasn't wealthy by any means, she made too much money to qualify for a regular medical card, but she didn't really make enough money to meet her basic everyday needs, but also pay for the Suboxone treatment, which itself is rather expensive. There was evidence that DHHR approved this special medical card not only through the terms of the improvement period, but through the January 3rd, 2019 review hearing, in which it was advised to the court that the special medical card had been issued, was paying for the treatment at Clarksburg Treatment Center, and basically she was doing well. There were further review hearings. Well, the next review hearing was on March 11, 2019 again. DHHR advised that MM was continuing to do well, complying with all terms of the improvement period, complying with the treatment at Clarksburg Treatment Center. She had not had a positive drug screen since, I believe, the onset of the case, sometime in October of 2018, and she continued to test negative for substances. However, when the parties convened on April 8th, 2019 for another review hearing, it became apparent that the special medical card had recently run out. Apparently they're issued on 6-month increments, and when this medical card issued to MM expired, the department refused to renew the card, and the department said, well, we don't issue special medical cards for purposes of Suboxone treatment. Obviously, that was completely contrary to what had been advised. Well, A, what had been stated for purposes of implementing the improvement period, but also, secondly, what had been advised to the court by DHHR in prior proceedings, prior review hearings. At the time of the first instance where this became apparent, April 8th, the petitioner by counsel, and I was counsel in the lower court, moved for an order to reinstate the card, given that DHHR had specifically issued that card at the start of the case for the purpose of Suboxone treatment, notwithstanding what their position might have been on April 8th. The court refused to do so. The result there was that the petitioner, MM, was forced to withdraw from Suboxone cold turkey, began suffering from dangerous withdrawal symptoms, and apparently began purchasing on the street Suboxone or whatever other drugs she could find to satisfy the cravings that are created by withdrawal from that medication. Additionally, she began failing some drug screens as of sometime in May. I don't know the exact date. I know by May 23rd we did have a positive drug screen. That was for methamphetamine. On June 3rd, we convened for a review hearing. And again, petitioner moved for reinstatement of the card. And the court's position in denying that motion was that the court, quote, had a problem with people being on Suboxone, end quote. On July 22nd, 2019, parties again convened for a review hearing, at which time petitioner again moved for reinstatement of the card. Instead, that was a dispositional hearing. Instead, on that date, rather than reinstate the card, the court granted the department's motion to terminate petitioner's parental rights due to noncompliance in the improvement period.
How long was she treated at the Suboxone treatment program during the period of the abuse and neglect case?
Your Honor, it was approximately 6 months, and it began sometime at the implementation of the improvement period. As I recall, that was in November of 2019. I can't tell you an exact date. But
and how did she do?
Well, according to the orders, reflective of all the review hearings, the department had no problem with her performance. She was complying with all terms of the improvement period. She was not only participating in the Suboxone treatment, but also she was attending the mandatory individual counseling sessions that go along with that treatment.
And was she visiting with her children?
I'm sorry, Your Honor.
Was she visiting with her children?
She was, as I recall, visiting with IM. As I stated before,
The other two were out of the house. She didn't have any contact with them.
Correct.
So she was visiting with the youngest one, right?
correct. The oldest child, also MM, as I said, from infancy had lived with the maternal grandparents. That child was born when petitioner was a teenager, as I recall. The other child was residing with relatives.
Well, let me ask you another question. What was the makeup of the MDT? Who all was on that?
The MDT consisted of the petitioner, myself, the respondent father, and that father was the father of the two younger children, as the oldest child had an unknown father in this case. There would have been counsel for the unknown father. I don't know to what extent that person participated in the MDTs given the circumstance, but the counsel for the known father, prosecuting attorney, guardian ad litem for the children, the maternal grandparents generally were participating in those MDT meetings, as well as the caseworker. Now, we had two caseworkers. We had one caseworker at the beginning that issued the card. We had another caseworker who took over, I don't remember at what point, but sometime approximately 3 to 6 months through the improvement period.
So the MDT comes up with the plan, and it's a child and family case plan, right? And it's normally issued by the department's representative, comes up and prints out the document that says this person will do A, B, C, and D. And so the department was part of that decision. Is that right?
Your Honor, that's correct. Yes.
All right. And so the initial thing was, okay, you're going to attend an in-state drug and alcohol treatment program, and we recognize that it's a medically assisted treatment program, and we're going to pay for it.
That is correct. What I would add to that is that I don't know what the department's policy in regard to in-state and out-of-state treatment is from circuit to circuit. I operate in a small number of circuits. I know that in the circuit, well, Randolph's in its own circuit, but in that circuit, over the last couple years, the policy of that department office has been that if the respondent parent in an improvement period in a Chapter 49 case is going to participate in Suboxone or just buprenorphine treatment, it must be through an in-state provider.
Yeah, I understand. There's a big problem with a quote clinic in Maryland where people go up, pay their money, and get their Suboxone and don't get anything else. And she was participating, apparently, according to the record, in Clarksburg, doing the counseling as well as taking the Suboxone. Is that right?
Correct, Your Honor.
And so we get down to this review hearing, and the department says, oops, we shouldn't have been paying for this to begin with, and we're not going to pay for it anymore. We don't pay for Suboxone treatment. Is that right?
That's accurate, Your Honor, 6 months in.
Right. And so there's a statute out there, if I recall correctly, that says that the burden is upon the person to get, meaning the parent, to resolve the conditions that are causing the abuse and neglect. However, if there is a financial issue, the department shall assist with financial issues. That's not an exact quote, but I'm paraphrasing a statute. Is that correct?
I can't cite the statute either, but I would agree with you.
All right. And so the department starts the treatment and then yanks the treatment, right?
Correct.
And would it be fair to say that but for the department pulling this treatment, this woman, at least to that point, had successfully met all the terms and conditions of the treatment of the child and family case plan?
That is correct. The orders reflect so. The transcript from every review hearing would reflect so as well.
And in addition to the department taking a position that they don't like MAT, especially Suboxone treatment. The judge said he had a problem with it and essentially said, I think that all they do is get them on it and then keep them there forever, and they never titrate them off. That's what the judge said, effectively.
That's correct, and that, I believe, is the department's reasoning for trying to keep these programs in state, because supposedly in West Virginia, we get them off that faster.
All right, right. Unlike the one in Maryland that just give me your money, you get the stuff, right?
Correct.
So that's all I have, I'm sorry.
Okay, I believe your time has expired, so I'm going to give you a few minutes just for rebuttal afterwards, but...
Well, Mr. Chief Justice, I believe the point has been made here. For 6 months, things were going well. The rug was pulled out from under the petitioner, something that had been promised at the beginning by the department was taken away at a point when she was doing fine. It's foreseeable to believe that she would have continued doing well in the improvement period, and arguments that it was an abuse of discretion to terminate parental rights rather than reinstate the card. So our request is that the matter be remanded to Randolph County Circuit Court to continue the improvement period.
All right,
Thank you.
Thank you.
Take your mic thing there.
Okay, we could hear from the response.
May it please the Court, I'm Lena Zgoda, Assistant Attorney General representing the Department today. The Department asks that the Court affirm the rulings of the Circuit Court below, and first points out that the Court did not err in denying petitioner's motion for extended payment of her Suboxone treatment after the first medical card expired. The statute that governs improvement periods that Justice Hutchinson mentioned does provide that the petitioner or the parent initiate services, and it also does have a provision pertaining to payment of those services by the department, but it provides that a court may order the department to pay for services required by an improvement period. Therefore, the language is not obligatory but is discretionary. In this case, the Court did not abuse its discretion in denying petitioner's motion for continued payment of Suboxone treatment when it based that denial upon sound findings. First, the record reflects that the Court considered the fact that petitioner had been using Suboxone for at least 5 years prior to the time that this case was initiated. In addition, the Court notes that the petitioner did not test positive for any opiates during the course of this case, but rather for methamphetamines, which are not treated by Suboxone.
How many times did she test positive for meth?
She tested positive once in May.
And
May
that would have
8th.
begun at the beginning of the case, right?
Well, she tested positive initially, and I don't believe that's part of the record. The exact date is not in our appendix record, Your Honor, but she also then subsequently tested positive on April 8th of 2019, but that was a preliminary positive, meaning the line was faint, and then when it was sent to the lab for confirmation, it did not confirm methamphetamines.
So that's a negative test.
Which, yes, is negative,
You
although...
got to take that as negative.
Yes.
That faint line stuff is...
I understand. However, then subsequently in May, petitioner did test positive for methamphetamine.
So how many times did she, from the time the case began through the time that the department withdrew the coverage, how many times did she test positive for anything other than buprenorphine?
I believe 2 times, Your Honor.
2 times, okay.
But may I point out this important fact that petitioner is not addressed, to my knowledge, in the pleadings or in argument. Petitioner's argument is basically based upon the notion that as soon as that treatment for Suboxone was withdrawn, or as soon as the medical card expired, that petitioner then began to relapse, and therefore she should be given another chance with this treatment reinstated. That's the gist of his argument. However, what he doesn't mention is the fact that petitioner in January of 2019, approximately 3 months before that card expired, began missing her screens. I'm not saying she tested positive, but she stopped stopped attending her screens faithfully beginning in January 2019. In fact, the worker at the dispositional hearing testified that petitioner missed the January 14th screen, she missed the January 20th screen, she missed the February 19th screen, she missed a screen in March, and then in April, she missed 3 screens. In May, she missed 1, tested positive once, and then stopped screening altogether. So to imply that that downward spiral just began at that point in time is not accurate.
Let me ask you, counsel, what the record reflects relating to the decision to not reissue the medical card. Was that decision individually related to the circumstances of this particular individual, and a decision was made based on the circumstances, we're not going to renew it, or was the decision driven based on a general policy of DHHR that we just are not going to be issuing in any circumstances, even with a perfectly compliant person, a medical card for Suboxone treatment?
So I did not represent the department in the case below, obviously, but I've consulted with a prosecuting attorney who did so, and also consulted with my client, and I was able to determine that there was an initial worker assigned to the case. That initial worker did not consult with the supervisor to clear issuing a special medical card for petitioner's Suboxone treatment. He issued that on his own without that supervision. Later, he left the department's employment. Another worker was assigned to the case. During her tenure as the caseworker for this case, the medical card expired. Upon expiration of that card, the second worker then went to her supervisor and asked if the card should be renewed. Unfortunately, there was some misunderstanding about what she was asking for. The supervisor believed the petitioner was requesting payment for out-of-state treatment for Suboxone, and I believe she'd been involved with an out-of-state clinic previously. She had been using that Suboxone for 5 years. So at some point there was a confusion on the department's part as to what she was requesting, and therefore she denied the renewed special medical card.
So
what was the answer to the question? Because Justice Jenkins asked, was it a matter of policy or was it an individual determination based on this case? And
Okay,
you just gave
I'm
us
sorry.
the factual recitation.
I'm sorry. Let me clarify that.
And what I'm hearing you say is that it was not based on this individual situation. This is just she was given the medical card originally in error based on a former employee's decision, and then when it came up for renewal, the decision was made, we're not going to renew it.
I can't really say it's an error, Your Honor. What I'm saying is that the department's policy is that it is willing to pay for Suboxone treatment as long as that Suboxone treatment is approved, as long as it will accept Medicaid payment through the Bureau of Medical Services. Typically that means that it needs to be an in-state treatment program. So what I'm saying is that that special medical card that was initially granted was granted based upon the supposition that petitioner was seeking in-state treatment. That was correct. However, later the department believed, misunderstandingly, the supervisor believed that that special medical card was a request for out-of-state treatment, and that's why the second request was denied.
So you're telling me this, had the department understood accurately that the treatment for Suboxone was in-state, the medical card would have been renewed?
I'm saying that there's every possibility it would have, yes. It would not have been against department's policy to do so. However, again, I have to point out that the petitioner's downfall began well before that card expired in January of 2019, that she has a 5-year plus history of abusing Suboxone prior to this time, that the court did not abuse its discretion in light of those facts in saying, I'm not going to require the department to pay for extended treatment. The statute doesn't make it mandatory for the court to so order.
So I'm a little confused, so I just want to make sure I know what the department's position is.
Yes.
My reading, and maybe I misread it, but my reading of the brief, of your brief, was that it was against DHHR policy to issue that card in the first place. And now you're telling us differently. I just need to know what the department's position is in this case.
Okay, let me explain what happened. That is, the facts as presented on the record indicated that it was against the department's policy. That is what the worker reported at that dispositional hearing. Okay, I'm not sure why she believed that, but that's what she reported. Upon investigating that, it came to my attention that that was not the policy. Therefore, the department's policy supports Suboxone treatment under appropriate circumstances. However, the argument that we're making today is that this particular case is not an appropriate circumstance, not because the department just won't pay for Suboxone, not because there was a special medical card involved, but because in this particular case, under the facts and circumstances presented, it was not appropriate to extend further treatment for Suboxone for this person.
But the issue here is the department worker, the new department worker, represented to the judge that it was against policy for the department, and incorrectly, but represented to the judge that it was the department's policy to not pay for Suboxone treatment. Counsel says, Judge, please order it anyway. And the judge said, well, no, I'm not going to go against that policy. Had the appropriate information gone to the judge then?
I would agree with your argument, Justice, except for this. On the record, the judge never mentions, I'm not going to require the department to do that.
Yeah, he mentions that I don't like these treatment programs anyway.
He does. However, Your Honor, he also gave petitioner an opportunity to present evidence to convince him that she was in an appropriate Suboxone treatment program. The petitioner made that motion first in April of 2019 at the review hearing, asked for the department to be required to pay for extended Suboxone treatment at that time. The court said, I don't like Suboxone. I know that people abuse it. I know that a lot of people get addicted to it. I don't really like that kind of treatment. However, he also told petitioner's counsel at that hearing when that motion was made, if you want to put on some evidence about that program, if you want to put on some evidence about what she's doing, I'll entertain that. However, petitioner didn't. Petitioner came back again the next review hearing in June of 2019, again had another opportunity. The court did not specifically call it out on that occasion. However, evidence was presented. It was a review hearing. The motion was renewed. He could have definitely put on evidence to support that. Nothing. Again, dispositional hearing, July 22nd, 2019. No evidence or testimony about this petitioner's participation in the Suboxone treatment, what it involved. Was she going to
Counsel,
counseling?
I'm going to interrupt a little bit because we need to give
Yes.
the guardian an opportunity to speak as well.
Certainly.
So I know we asked you several questions, so we understand, but I'm going to ask that you wrap up your portion. So.
Yeah. So essentially, we're asking the court to affirm the rulings of the circuit court, also pointing out one last point, that at the time of disposition, petitioner wasn't treating her drug problem. She'd been given an option for alternative means of treatment, such as detox and inpatient treatment during the course of her extended improvement period, which was granted by the court, and she failed to take advantage of any other source of treatment, attempt any other source of treatment, stopped attending parenting and adult life skills, stopped screening for drugs, and stopped visiting her children. So at the point of disposition, when the circuit court reviewed this issue for disposition, petitioner was doing absolutely nothing in conjunction with her improvement period. That's all I have. Thank you.
Guardian, please.
May it please the court, my name is Tim Prentice. I'm the guardian ad litem in this matter. This case is a very difficult case for me because I do feel that the mother, her case was, her improvement plan was interfered with by the actions of the department. However, the remedy I think that is most obvious would be to reinstate the improvement period with the mother receiving appropriate services, including Suboxone, if her physician prescribes that, and allow her a chance to complete her improvement period and ultimately have the court decide whether reunification is appropriate. However, that further delays permanency for the kids. So it's it really is a case where it's hard to craft, I think, a reasonable remedy without, either hurting the mother or hurting the children, or potentially both. But I think the important thing in this case is that if it's the position of the court and the legislature that medical assisted treatment is appropriate for addicts, and that would include use of Suboxone. My understanding from those programs is that there are wean and taper programs where the dose is reduced and the length of time between doses is increased, and that there are maintenance programs, which are in essence, you're kept on the substance for potentially life. And I believe that this may be the kind of program that the respondent mother was on. The respondent mother, in essence, became habituated to the use of Suboxone. She apparently was using it correctly because she was able to get her life together, not completely, and my summary says that she was adequately complying with her improvement period, because there were mistakes, including failure to call in and failure to get some tests done. Now, this call to test program is a daily program, Monday through Friday before, I believe, 10:30 in the morning, something like that, that the respondent has to call in. And then he or she's told whether or not they need to test. This results in generally speaking, dozens of, at least a dozen tests a month. So it's not uncommon. In fact, I don't think I've ever seen a case where a respondent would, without any omissions, complete their tests. Omissions, missing tests are common, and these are actually few missing tests compared to a lot of improvement periods that I've seen.
I'm sorry to interrupt, but we're running a little bit over time.
I'm sorry.
And I know some of what you're saying here was already presented by the counsel for the respondent. So I'm going to have to ask you to wrap up and summarize.
Okay, if I could just have a moment. Your Honor, I think that the mother needs an opportunity to have consistent treatment, and then some remedy applied to allow her to have an improvement period that is meaningful, because it's my position that by taking away her Suboxone midstream, it deprived her of a meaningful improvement period. And I think that it was in the best interest of the children that she have one. I believe the court thought that as well, or it wouldn't have granted one. And for that reason, I ask that the court craft some resolution that won't extend this much further for the children. Now, I know the COVID-19 problem that's also extended matters, but on the other hand, is fair to the mother, and I appreciate the court's time.
Thank you. Is there a brief rebuttal from the petitioner?
No further argument.
All right.
May I ask one question of either the guardian or counsel? What evidence was there regarding the older two children that her conduct put them at risk, and therefore her rights to those two children should have been terminated? Was there any evidence to that effect? And you can answer me from there if you want to.
Your Honor, I didn't think you picked up on the webcam.
I'm sorry, never mind. You need to go to the podium. I'm sorry.
Your Honor, as far as the oldest child, MM, is concerned, there really wasn't. I mean, I guess to some extent the department might have alleged a degree of abandonment. However, it had been, that was the arrangement from the child's birth. As I said, that child was born when petitioner was a teenager. I don't know exactly what age, but that had been the arrangement. I don't know that it was specifically alleged, but to some extent maybe that was a reference to in the petition. As far as the other child goes, probably something of a similar extent. I mean, it was an agreed arrangement where the child resided with the family member in Washington County, Pennsylvania.
But there was no specific allegations in the complaint that her conduct put those children at risk. Am I reading that
Correct.
petition correctly?
I'm sorry, Your Honor. Yes, it was the onset of the case was an instance where petitioner was working in a restaurant. The respondent father was waiting for her outside to get off
I've
work.
read that part. I understand that part.
That was the impetus for the case.
All right, thank you. I don't want to run us too long. I'm sorry.
All right. Thank you very much for your arguments. This case will be submitted.
The next case for oral argument is also presented under Rule 19, in re AD, GD, and ED, docket number 19-1042, an appeal from the Circuit Court of Taylor County. And I will let you know that although Justice Workman is not in the courtroom, today she is viewing and listening and will be participating in the decision and opinion in this case. I'll remind counsel that you each have 10 minutes per side. The respondent's counsel needs to split those 10 minutes, and there is now a clock right there beside the podium, so please keep track of your time. Thank you.
If it please the court, I'm Laverne Sweeney from Grafton.
Sweeney, you can remove your mask if you have the microphone cover on.
Okay, thank you, Your Honor. Anyway, I'm Laverne. With an abuse and neglect case, obviously they're looking if an improvement period wouldn't work, and it couldn't work in this case, that there be some permanency, finality, and they're looking at an adoption. And as far as the last case that I could find, which was in Re KL, the court said we now specifically hold that only familiar preferences applicable to adoption of a child are recognized in this state. One, a preference for adoption in the placement of the child with the grandparent as set forth by another statute, and second, preference for placing the siblings together. And the petitioner is a grandparent. She tried to intervene. It was rejected the same day. And anyway, so there were basically a denial of due process. She wasn't given the opportunity to be heard.
Counsel?
Yes.
One, I'm very concerned about the brevity and how limited the briefing was in this case. And I think the petitioner's argument is essentially 3 sentences long in its entire brief, the substance. The other, and you just mentioned the grandparent sought the preference, and you cite In Re JP. In Re JP, the grandparent petitioned essentially on day 1. In this case, the grandparent petitioned a year later. Can you explain the reasoning for the year delay in the time for the grandmother to seek the opportunity to intervene and be considered for a preference?
I'm not real certain. I think this is my own thought, is that she didn't know how this was going to play out, so to speak, in terms of what the final result was going to be, and it didn't turn out that way.
What sort of principle should we, obviously the statute recognizes a grandparent preference, but let's say the grandparent waits a year or 2 years or 10 years. At what point do you think we should say you've lost your opportunity to seek your preference?
I would say 2 to 3 years, and the basis for that is that, and I don't, this is just off the top of my head, and I don't have the exact citations because I didn't I just didn't have them, or don't have them at the present time. But there were a couple older cases where the case got sort of lost in the department, and the children were with the foster parents for an extended period of time, and the decisions out of this court on at least the two cases, and if you need me to provide the citations, I can get them because I haven't, but I just don't have them here today. Anyway, they said, well, you got to look out for the child's best interests, and you know, if there's a 2 to 3 year delay, then we're just sort of going to overlook what went wrong, and we're going to go ahead and you know, allow the children to stay with the foster parents. And so that's why in terms of my response, it's based on those couple of cases, and I'm certainly willing to provide the citations.
But if I understand you on the first part of that question, you kind of made an assumption, but you don't know why that the grandmother waited a year before seeking to intervene for the grandparents' preference consideration.
And that's just my assumption, is that it hadn't happened initially, and that the court, it was, you know, some time before that was basically finalized. She wasn't, you know, on official notice. I mean, it was her grandson, so she obviously knew about that. But as far as being officially notified, she wasn't a part of the case.
I understand that.
Right.
I was trying to avoid what your assumptions were.
Right.
And if there was
I
an actual
understand.
representation of this court that the reason for the delay was ABC, and it sounds like you cannot offer, in fact, exactly the reason for the delay, other than your assumption.
That's correct, Your Honor.
Thank you.
She was not she did not have any kind of custodial responsibility for this child at any time. Is that correct?
That's wrong. From birth with GD, she was basically taking care of GD a lot of the time. With AD, it was less because the other grandparent, the maternal grandparent, seemed to be working more with her. And of course, ED wasn't born till after these proceedings.
Well, the record seems to indicate, or at least the information I have, or that I've read, is that at the time of the filing of the petition, that the grandparent, this grandparent, did not have custodial responsibility for any of these children. That's what the
in terms of official custody, these children were basically, you know, the parents were drug addicts and they were farming their kids out, and it was actually, they were the ones that suggested the SW be granted custody.
The judge ordered the MDT, or ordered the department to do a home study. Did they ever do a home study?
The last update, my client says no home studies have been done. The last update, and I think it was around May of this year, was that the department said that there have been no home studies of my client.
All right, thank you.
Okay.
That's
If you wish to reserve a few minutes for rebuttal, then I believe your time is
okay.
expired.
Thank you.
So, thank you very much. I just would reiterate what the clerk has said for the respondents, that you have 10 minutes to gather. So hopefully you've worked out how you wish to distribute that. Okay.
May it please the court, my name is Minnie Parsley, Assistant Attorney General representing the DHHR in this matter. I am going to get straight to, I believe, the point that the justices have been making thus far. Petitioner's chief argument is that she was denied a motion to intervene in the abuse and neglect proceedings below, and that the court erred in not granting her standing. I believe that the proper analysis for standing is whether petitioner was a party having custodial rights or responsibilities to the children at the time she filed the motion to intervene. Here, the record establishes that petitioner waited nearly a year after the institution of the abuse and neglect proceedings to file her motion to intervene. And according to that same record, there was no contact with either the department or the guardian ad litem previous to filing her motion to intervene. Further, petitioner's motion to intervene came after the respondent parents' parental rights to the two older children, AD and GD, were terminated, after the respondent mother's parental rights to ED, the youngest child, the subsequent born child, after respondent mother's rights were terminated to ED, and when the father was in the dispositional phase for ED and while his parental rights were still intact to that child. Based on the record below, and because the petitioner was not either a biological parent or an adoptive parent, this court's focus and the courts below was properly on whether the petitioner qualified as a party having custodial rights or responsibilities, which would entitle her to greater rights bestowed by West Virginia Code 494601H. Again, turning to petitioner's argument, she's
So backing up there,
Yes.
because you're sort of creating a two-part, it seems to be, analysis for this grandparent to have standing. What is you're suggesting that they don't have it to begin with purely by virtue of the grandparent statute, that they have to do something else? And if they do, then what do they have to do?
I do think that they are separate issues. I think if a grandparent is filing a motion to intervene, and I believe this is also supported by decisions by this court, and it could be any relative or someone who is saying that they had some sort of pre-petition or custodial responsibility to these children. If they are filing a motion to intervene, and if it's granted, they are getting a right to be heard. So I believe...
But a statute vests a special sort of status on grandparents. So
Right.
you just looped in a whole bunch of other relatives
So-
who might have some kind of responsibility. But I'm focusing on
Grandparent preference.
At what point does a grandparent gain the standing to enforce their statutory preference?
According to the statute, for the grandparent preference to apply, it has to be at that post-dispositional, that adoptive phase. So once the grandparents are identified, and I think the facts here, and I know that the guardian can speak to that as well, is that even after filing her motion to intervene, upon being interviewed by the guardian ad litem and the department workers, that the grandmother the petitioner in this case, still did not make her intent to adoption known. But I do think that the grandparent preference applies at the time for adoption. I think standing and filing a motion to intervene in an abuse and neglect proceeding and the grandparent preference are two different issues. I do not believe, and I don't think that case law or the statute necessarily supports a grandparent's right to intervene in an abuse and neglect proceeding simply because they are a grandparent. I think if that grandparent can point to a pre-petition custodial relationship, if they can say the children have lived with me from X, Y, and Z, they are living with me, they have been living with me, then they too might have a motion, or they might have the right to intervene. But there have been at least a couple memorandum decisions and State XREL v. Bloom where the court found that a grandparent did not have the right to intervene, but then was later the caretaker for the children. They were placed in his care by the DHHR, and then later he was given pre-adoptive parent status, so he was able to be a party to the case. But this court did not grant, they affirmed the circuit court's not granting him as an intervener, and he had the children close in time to when the petition for abuse and neglect was filed. In this case, even by grandmother petitioner's own admission, she had not been providing care for the two oldest children. I believe it was approximately 2 years before the abuse and neglect petition was filed. I think the facts in this case also bear out that these children were being passed around amongst several family members over a 4-year period before the abuse and neglect proceeding was initiated, and that included the third cousin who they were placed with upon removal and who they remain with today.
Counsel,
Yes.
something that I'm concerned about of the Circuit Court's order, in its order denying the grandmother's motion to intervene, the Circuit Court cited syllabus point 4 of In re Michael Ray T. and used it as to support its finding that the grandmother had no standing to intervene. But In re Michael Ray T. addressed a foster parent and not a grandmother.
I agree, and I think that the court would have been better to use 494601 and the cases that are cited in that statute, because it does lay out, along with 491204, which establish what custodial responsibility is within the context of Chapter 49, and then who has a right to be heard in an abuse and neglect proceeding. And it lays out who could be an intervener and why they might be able to intervene. It lays out the right to be heard and what upon being granted intervener status gets you in the abuse and neglect proceeding.
So you think your suggestion is they got it right, but got it right for the wrong reasons?
I agree. So they do mention foster parents in the 494601 right to be heard, but they do distinguish that someone or parties or persons, I would say, that are given custodial responsibility of children or a child after the institution of an abuse and neglect proceeding have a right to be heard, but not necessarily the full right that an intervener that could come in the beginning because they had the children before the abuse and neglect proceeding. So even the statute and the cases that fall along that statute make a distinction between pre-custodial relationships and then foster parents, pre-adoptive parents, or any other caregiver that might have also provided the children care. So,
Counsel, I hate to interrupt, but in order, if we're going to be able to have hear from the guardian, I would ask that you wrap up your argument, please. Thank you.
I've got about 50 questions. I'm keeping my mouth shut so I don't lose over time.
At least 50.
This is a catch-22.
May it please the court, my name is Mary Nelson of Mountaineer Legal Services, and I'm the guardian ad litem for the minor children in this matter. I would agree with the representations made by the Assistant Attorney General with regard to the reasons why petitioner does not have standing to be an intervener in this matter, and the code section that she was relying on being 494601H. So I can get into that, or since our time is somewhat limited, I would prefer to go into the issue of the grandparent visitation and the grandparent preference statute. The grandparent preference statute that's set forth by 494114C that counsel for the petitioner sets forth as his grounds for her right to intervene is not an absolute right. Always when looking at that, it's a preference. It's not absolute. The best interests of the children are the paramount concern. That's been cited repeatedly by the court in re KE. That the necessary determination is what placement would serve the children's best interest. And I think it's critical to review, and I know we have the timeline of the case in relation to when the petitioner sought to intervene and how the children are functioning now. The reality is that
does the department have an obligation at the beginning of a case? If it, most of these cases run on a dual track. You got the one track looking to terminate or get them back together. The one track's trying to reunite, but the other track is saying if that doesn't work, we're going to do an adoption.
Concurrent planning, correct? Concurrent
planning. Thank you. I couldn't think of the term.
And the department did engage in concurrent planning.
Did they identify this grandparent? And when did they identify this grandparent as a potential placement for this child?
It's my understanding that the paternal grandparent was ruled out relatively early, in that the parents identified that they did not want her considered for placement. And I would note that the paternal grandmother did make contact with the ongoing department worker, Amanda Newman. Ms. Newman indicated to me that she spoke with the paternal grandmother for over an hour, and that she never once in that hour indicated that she wanted placement of the children.
Well, at what point do individuals charged with abuse and neglect get to dictate who gets the child? I mean,
no, my point, Your Honor, is that in the conversation that the ongoing worker had with the paternal grandmother. The paternal grandmother's concern at that point was visitation with her grandchildren. It was not placement of her grandchildren. That she did not raise that as an issue.
The statute says they have to identify a potential grandparent. Did they do that, and did they do a home study to either rule her in or rule her out?
A home study has not been done, but I would indicate that there has been subsequent information that has come to light by the MDT that would indicate that the paternal grandmother is not appropriate and that she would not be considered by the department. And this information, I mean, I have a series of conversations.
Is it part of the record?
It is not. It came to light on
Then we don't need to talk about it.
8/28/20
We
in
don't
the
need to talk
afternoon.
about it. All right, go ahead. I'm sorry.
That's okay. I would have supplemented the record, but as I said, it was Friday afternoon, late in the day. So I figured it was too late to supplement the record. But I think that it's important to look at how the children are functioning. Petitioner actually sought to intervene 7 months after the right of the two older children, AD and GD, were terminated. If you look back at the adjudicatory hearing, there was testimony that was taken that GD had been homeschooled and educationally neglected. He was held back in the 2nd grade and didn't be promoted. Since he has been with the relative kinship foster care placement where he has been for the last 2 years, he's thriving. He's an A student. He also had speech therapy for the last 2 years. He had a severe speech impediment. He is now easy to understand. I visited with all the children in the home. They're happy. They're well adjusted. ED came straight home from the hospital to this home. It's the only home she knows. She's been there her entire life, about 15 months. She looks to the relative kinship foster care placement as her mother. In addition, the middle child, AD, is 2 when she was placed in the home of the relative kinship foster care placement, 3 by the time the paternal grandmother made her petition known, and she's now 4. So she also looks to the relative kinship foster care placement as her parents and her home. It's the only home she knows.
Counsel, I have to ask you to please conclude your...
Okay. I just want to indicate that the children are thriving and that they're doing very well, and that the MDT has met on 3 occasions and discussed the appropriateness of the relative or the petitioner grandmother, and discussed the possibility of ongoing visitation and concurrent planning, and has ruled that out. But I believe that it was appropriate for that matter to be referred to the MDT based on the code sections that I've already cited and which were also relied on by the Assistant Attorney General.
Thank you.
Please take your microphone cover with you.
All right, we have a brief rebuttal.
I have some major concerns here. For what I've basically just heard is that I'm basically getting blindsided by a lot of material that I don't have any access to, don't know anything about as far as this, and don't have any basically right to cross-examine. This mention of Linda Newman and talking about she never asked about having custody, having adoption. She had only asked about visitation. So I haven't seen that material really before until I'm right here. And what I really think should happen here in the best interest of justice is that the case should be referred back. She should have, the grandparent, my client, have an opportunity to defend herself, an opportunity to cross-examine these folks, opportunity to present her own evidence so that the trial court could hear this instead of we getting down here and at the very last moment just basically getting bombed. And so for that reason, that's my recommendation as to how this case should be disposed of. Thank you.
All right. There are no questions?
We've been looking for work for Edie, so now we've got it covered.
All right. Thanks to each of you for your arguments, and this case will be submitted.
Thank you.
All right, the next case for oral argument this afternoon is In Re LC, docket number 191184, an appeal from the Circuit Court of Monongalia County. And I want to let you know that although Justice Workman is not in the courtroom today, she will be viewing and listening to the oral arguments and will participate in the decision and opinion in this case. I'll remind council that you may come up, your case has been called, but I will remind you that you have 10 minutes per side to argue this case, and the respondents need to split that 10 minutes. We do now have a clock right by the podium to hopefully help you with that. But counsel for the petitioner, you may put your microphone cover on, remove your mask, and proceed. Thank you.
May it please the court, can everyone hear me with the mask on? I just feel uncomfortable taking it off, but if you can't hear me, I will remove it.
We're able to hear you.
Okay, thank you. Good afternoon, ladies and gentlemen of the court, and may it please the court, my name is Amanda Ray, and I am here as the petitioner in this case on behalf of AT and LC, as far as I'm concerned. I would like to reserve 2 minutes for rebuttal if necessary, so please feel free to stop me at the 8-minute mark. This case has frustrated me for quite some time. Every single assignment of error that I put in this brief is based on the court's failure and the department's failure and in general failure of parties to follow the law and policy and the rules of appellate procedure or just procedure in general for abuse and neglect cases. Over and over again, there were instances where things were not done as they should have been done. For example, early in the case, it's required under West Virginia law to file a family case plan. That is to give us a roadmap that is modifiable, that lists out what everyone needs to do, what's expected of the parents, what's expected of the department, and the court's responsibility is to hold us to that plan and to make sure that the case is being properly managed and that things are happening for the family to promote either reunification or adoption, or whatever the plan is for permanency. Now, in the case before us, the plan was reunification. It was from the beginning. There really wasn't any concurrent planning, and there was no family case plan that got filed. Despite this, there were things in the orders that were required of the mother and the parents in general. AT had to do drug screening. AT had to make improvements to her home. She was required to do parenting and adult life skills and to try to show that she could provide a safe and stable home for her family. And then we'd go to court. And she did really well in that first year. In fact, she had almost 1 year of clean drug screens, and the child was returned to her in June of 2018, about 10 months after he had been removed from her home. Or right at the 1 year mark, I think. She had, in that intervening time, cleaned up her rental. It was a trailer that she did not own, but she made the repairs herself, she and her father. She had been drug screening. She had been participating in everything. And the guardian ad litem, the department, everyone was on board to allow the child to come home. Now, LC himself had had some problems. While in care, he was moved from his initial foster placement into a kinship home. Then there was allegations of possible sexual abuse or sexual touching that LC reported while in the kinship placement. A CAC interview was done. He was moved. No follow-up happened on that, though. They never really investigated, and the child received no counseling or therapy, and we really didn't know what happened with that. And he failed in that foster placement and was hospitalized for the first time. He did have contact with his mother, and that contact went so well that he was returned. Then we had an entire summer of good contact with parenting. The parenting provider was in the home. The DAL made a visit to the home to see the child. The department worker was in the home several times. I made a couple of stops into the home to visit my client, check up on things. Everything had gone well. By the end of July, we've got a recommendation that we might just close this case. Obviously to continue services because of the child's behaviors and things that had happened to him, but we were on track. And then we had something that happened, which is the child returned to school, first grade. He started having behaviors at school. He had had behaviors in school before in Preston County and in Roane County, where he had gone to school while in foster placement, but this was the first time he had been with his mom. That September 11th, 2018 hearing is a prime example of everything you should not do. It was set as a 30-minute hearing. There was an expectation based on the MDT the prior week that we were going to, okay, the child had had these behaviors, a CPS call had come in, and the department had gone to check out the home. The home was fine, but there were some things that needed to be addressed. So we weren't going to close the case anymore, but we were going to give mom a post-dispositional improvement period and follow up on these behaviors. And then we showed up for the September 11th hearing. And that 30-minute hearing tunneled right in. I didn't get an opportunity to object to the fact that the state suddenly presented 3 witnesses that I was not notified about in advance. And the court decided to call a witness, which was the CASA worker, and ask them questions, which is fine, but it would have been nice to know in advance that at least 2 out of the 3 witnesses that the state called were asking for removal of the child from the home because of his behaviors. And some of them had fault with my client and stated that the fact that she had had 2 drug screens that came in that ended up being positive right before we returned the child. So this is after almost a year clean. She had had 2. Some might argue self-sabotage, or she was just depressed that visit didn't go through. But she was still in treatment. We had left the child in the home over the summer, and she hadn't had any additional clean or positive drug screens. So
at that September 11th hearing, did you seek a continuance in order to call witnesses on behalf of your client?
Yes, I actually asked the court to please set this so that when I finally got the opportunity to address things, I said, this was not what we prepared for. I filed a motion for a post-dispositional improvement period, not a termination hearing or a removal hearing. And I was basically told, I think we were there 2.5 hours. If you look at the transcript, it was a lengthy hearing. My client didn't get to testify. We didn't get to call any witnesses. I wasn't prepared to call any witnesses other than my client because I didn't know that I needed to have anybody there. I did get the opportunity to question the state's witnesses, but I did bring up that we needed to have another hearing. And when the court said that she was removing the child, she said it was so that the child could receive help, more intensive help, than what was already put in place. Now,
Counsel, just so you know, if you wanted to reserve a few minutes, you are up on that time. So if you want to reserve a few minutes for rebuttal, I'd ask that you wrap up your argument.
Okay. I don't have a whole lot more, but thank you. That was really where things started to go downhill, was that hearing. The child was removed. Services to mom were stopped. Essentially, the department seemed to be split. Half of them decided that mom had already, for some reason, someone who had done so well was now horrible and was never going to do any better. And contact between mom and the child had been stopped for various periods. I had requested a hearing on September 21st because the child was not immediately removed. And I included the email which basically said that Judge Tucker felt that a hearing did not need to happen. Well, by law, if you remove a child from a parent's home, you have to have a hearing. You're supposed to have it in 10 days, but you have up to 60. Did we have one? No. We did not. We had a regularly scheduled review hearing, which was almost 90 days after that hearing. And all of these issues just snowballed from there. The department didn't provide services for mom, even though they were ordered. The department didn't help mom with fixing her phone. The department didn't help ensure that contact could happen with the child. And here we are, over 3 years later, and this child doesn't have permanency. He's a legal orphan. He's never survived in a foster home more than 3 months, and the court knew that going in, which is why I objected to the termination. This is a child that, my client had shown that she could do this, and we had given the child back. So I don't think that what the state did was correct, and I think that considering the child remained in a hospital placement until January of 2020, and still hasn't, to this day, managed to go 6 months in a foster home, that there was a concern to terminate immediately, as the state insisted on and as the GAL supported. And all of this goes back to my assignment of errors, because if we had simply followed what's in the bench book for abuse and neglect, if we had followed the law, if we had followed the policy and helped this family, we would not have a legal orphan out there whose mother's rights were terminated, and he has no one.
I believe we
Thank you.
understand your argument. Thank you. If we could hear from the respondent, please. Again, I would just reiterate what the clerk has mentioned, that the two of you need to share your time. So if we get short on time remaining, I may remind you of that through the argument.
Court, my name is Sandra Evans. I'm an Assistant Attorney General representing the Department of Health and Human Resources. I think that I'd like to just start with a couple of things. I believe that the court below got the decision correct. She did what was in the best interest of the child, particularly given the fact that there was no reasonable likelihood that the mother could correct the conditions of abuse in the near future, and because the case was against the statutory maximum period of time. I'd like to talk a little bit about the child. From what I gleaned from the record is this case started when the child was 4 years old. He was practically a baby. The department had instituted services for the family in order to make sure that it was safe for the child based on their first referrals. And they did that in April of 2017, and they came back in June of 2017 because that didn't work, and they filed a petition. The child began to say or to disclose things that are absolutely unheard of, I think, for a 4-year-old child. The only way he could have known about some of these things is that if he had actually been through them. He talked about needles and subs. He talked about the parts of the body that his parents used the needles and the subs. He talked about being sexually abused. He talked about his father abusing him, sexually abusing him. He talked about someone named Wade, I think it was, who sexually abused him. He had a number of different things that he talked about that he could have only known about had he experienced them or been right there with them. Now, the basis for the filing of the petition was domestic violence, a dirty home, and drug use. The mother received, after the petition was filed, she received and requested and received post-adjudicatory improvement period. She asserted that it was her drug problem that caused her to be an inappropriate parent. When you receive an improvement period, it is absolutely the recipient of the improvement period, it's that person's responsibility to complete what's in the improvement period. Now, there has been mention about the department not following the family case plan, and I cannot find that family case plan was filed at the beginning of the proceedings. And the reason for the family case plan, as has been explained, is to provide a logical sequence of occurrences that will help the person become a better parent so that they can take their child back. However, all through the record, there is mention of reunification with the parent. There are mentions of what she was supposed to do. There were no questions. She didn't seem to have any questions about what she was required to do. It had pretty much whittled down to a clean house and no drugs because the father was no longer in the picture. He was incarcerated at that time. So there were a number of errors that were mentioned, but I could not find anywhere in the record where the mother indicated that she was confused about what she should have been doing. Services, there was a mention that the services were not provided by the department, but when you get an improvement period, not only are you supposed to do that, you're supposed to do what you're supposed to do under the plan that they had, which apparently was discussed, had to be discussed somewhere, at the MDT or in some of the proceedings, because she was doing something. In addition to that, once you get an improvement period, then what you do is you proceed along the lines of that, and if you have questions about it, then you bring it up at an MDT. But the other thing is that the mother had problems, and she had problems with the same thing that the petition was brought on, and that was with drugs. The child had problems, as has been mentioned before. He had problems with trying to disclose what had happened to him and didn't seem to be able to do that. But the mother's services, that's what I meant to say, was the services that she had were terminated because of her noncompliance. She had gone so far, and then she stopped doing things, and I think that's where she fell off, and she began to use drugs again. But in terms of this child and what he has gone through and what he's had to go through just to be able to try to find out, he keeps talking about a secret, and they still, as far as I can tell, have not determined exactly what has happened to this child, but there have been a...
So we received an update recently. This child is 7 years old now and is apparently making allegations about, enhanced allegations about sexual abuse that have been made very recently. What's the plan for this 7-year-old child?
The plan is to try to get him therapy so that he can be adopted. That was the concurrent plan. First, there was a reunification, which fell through, and then there was supposed to be an adoption, hopefully with a family, that foster family, and that foster family would then adopt him.
And where's the child? Is the child in foster care right now?
The child right now, as far as I know, I'm not sure where he is. The guardian ad litem could probably answer that better than I could. But his most recent therapy sessions were with someplace called United Summit. And I think he was released from that, and I'm not sure right now if he's in foster care or continuing in treatment.
So this child has been sort of drifting through treatment for a couple of years now.
Well, it seemed that he would get better, he would get out, and he would have these terrible meltdowns. He would do things like slip himself underneath covers at school and say he was going to have sex with people. His behavior was very strange for a child that age. Something had to have happened to him. The experts couldn't decide whether it was trauma-based or ADHD. He was given medications for a while, and nobody seems to be able, until he is able to disclose what happened to him, to know how to treat him. So I do believe that the court came to the correct decision. She looked at the child and said that he has problems, and those need to be dealt with. The mother has her own problems as well. But what she decided to do was to try to find treatment or something, to find out what's wrong with him so that he can be treated and he can be adopted and have some permanency. So the department believes that the court made the right decision, exercising her discretion in the best interest of the child, and we would request that the decision be affirmed.
All right. Thank you. Good, now hear from the guardian ad litem.
Please the court, Scott Schuff, serving as guardian ad litem for LC. To answer your question, Justice, the child is currently in St. John's Home for Children, which is in Wheeling. He was always in counseling of a general nature in that placement, primarily for PTSD and behavioral issues. In light of the new disclosures that he made on August 25th at the CAC interview in Morgantown, that counseling is going to be expanded to help him deal with the issues that he's recently been speaking of. Unfortunately,
Counsel, on the issue, Has the child expressed any interest in returning to the care and custody of the mother?
He expressed that primarily when he was placed in Tennessee, Your Honor. He knew that that was his mother. He had a bond with her. That simply wasn't possible then, given her behavior. I have not specifically asked him that question since he's been placed in Wheeling. I will say that he has been unsuccessful in 2 foster to adopt placements so far, but when speaking with the DHHR worker who's assigned for permanency, there is another possible foster to adopt placement that is being explored currently. So again, the ultimate goal is adoption for LC.
And we know from the record that I believe the mother visited with the child twice in 2019, if I'm not mistaken. What about in 2020? What contact, if you know, has there been?
I am not aware of any contact since he's been returned from Tennessee and since the termination hearing was conducted.
How long was he in Tennessee?
Over a year, Your Honor.
And I'm familiar with that facility, and I understand that they try and accommodate family treatment. They do some via phone, but they also like to have a couple times for the parents to come down. Did the department help her get down there?
I believe they provided some assistance. I'm not sure they provided everything that she would have needed to make those trips.
Yeah, in fact, I think the record indicates they paid for 2 and didn't accommodate her on the rest. Is that fair?
I believe that's correct.
Okay.
But the court should know that she also lacked a driver's license throughout the entirety of the case, and there were inconsistencies as to her maintaining her sobriety, which also raised concerns about whether she could make the trip or whether the trip would even be worthwhile.
Let me ask you this. Since removal from the mother the second time, all right, how long has this child been in a hospital facility or congregate care?
He would have been in Tennessee over
a year,
14 months, I believe. He was then placed in a foster to adopt home, which failed.
2 months, right?
That sounds correct, Your Honor. And he has been in the children's home in Wheeling since the failure of the second foster to adopt home. So approximately, I would say probably 16 to 18 months he's been in either a group home or a medical placement.
And he's currently in a congregate care?
Yes,
facility.
yes, sir.
Okay, thanks.
The fundamental issue, though, from the perspective of whether or not this mother should have been terminated, is her failure to simply correct the issues that were in the petition in the first place. She did not maintain sobriety. She did not maintain stable and appropriate housing. And toward the end of the matter, she re-engaged with the biological father, who had been recently released from prison, and brought all of what appears to be the post-traumatic stress issues back into this child's life. She had been repeatedly told that he, the biological father, was not to be around this child because although the disclosures had not been clear and concrete, there had been an undertone of concern about what this child had been exposed to and why his behaviors were as they were. For whatever reason, she did not follow that guidance, so that again caused concerns about whether this was an appropriate placement for him.
Counsel, I'm going to have to ask you to please bring your...
Overall, the simple matter is that the lower court was correct in ordering the removal of this child from the biological mother and was also correct in ordering the termination of her parental rights. Thank you.
Thank you. We have a brief rebuttal.
Thank you, Your Honor. Please support. I can clear up a couple of things there because I know this case inside and out. The lower court was not correct in what it did, and frankly was horrendously overjumping things in terms of asking for termination in November of last year when the child hadn't even been released from the hospital yet, and he was wrongfully up, when he was released from the hospital in Charleston to his mother's care, she was tasked with getting him signed up with United Summit Center, which she did. He had a meeting with the psychiatrist on September 25th. He was removed on September 11th. That was the earliest meeting with the psychiatrist she could get. He had done 2 prior meetings for intakes, and he had also met with his pediatrician for his medication management. He was in parent-child interactive therapy with his mother. He was doing counseling through the Monongalia County Child Advocacy Center. And on September 11th, or actually, we had the hearing on September 11th, but when he was eventually removed 10 days later, on September 21st, he lost his psychiatrist. He lost his family doctor. He lost.
So let me move forward just a little bit, since our time is quite limited. You're talking about the occurrences, and you've done an excellent job of outlining the deficiencies that you contend exist in what the department did and what the court has done in this case. But my question is, what has your client done to demonstrate that the termination of her parental rights in 2019 was incorrect?
Okay. And one other thing to correct, the child is 8 years old. He turned 5. His birthday's like July 15th. So he turned 8 this past summer. He was 5 right after he was
I stand corrected. Thank you.
All right. My client had corrected everything. The father was in jail, okay? So domestic violence was not part of the home. The home had been cleaned up and had passed inspection for quite some time. And she had almost, like I said, a year clean of drug screens before the child was even returned that summer. So she had corrected everything that was in the petition. We were thinking of closing the case, remember, until the child had the behaviors.
So my question, again, in limited time, if you could go to 2019 for us.
Right.
We definitely, from the record and everything, understand and can appreciate your arguments about the deficiencies in 2018, but we're here about a termination that occurred a year later, when it appears that your client had gone back to prior behaviors, was testing positive for illegal drugs, and so we have to take a look at what the court was looking at in the course of terminating the parental rights.
Yes, thank you, Your Honor, and I apologize. I was getting to that. I'm probably more long-winded than I should be.
You're very passionate, and we appreciate that.
When that hearing happened in September, the department decided they weren't going to provide any more services to my client. She had been making liberal use of those adult life skills services for transportation purposes and for assistance in obtaining food and other things, and also to get to drug screens and things. Now, she managed to do pretty well for a while, and it wasn't until, well, there were 2 big things that happened between the removal in September 2018 and throughout 2019 that threw my client off and probably served as some of the biggest setbacks for her, other than the department pulling services. One, SC, who's the father to LC, was released from jail. He kept pestering my client, wanting a place to stay, wanting her to take care of him. He bounced around. He would show up at her house. She managed to stay away from him for quite some time, and then in January of 2019, her father died. And her father had been living with her during the pendency of the case, so she was extremely close with her father. That sent her spiraling. So it wasn't long after that she lost her housing, she lost her cell phone, she got back together with her ex. It was just a mess. And the other thing that happened is that she and I had been requesting at the MDTs to have the department provide money, or the department worker went to Tennessee every month to see LC, but they wouldn't give her a ride. They wouldn't pay for a bus ticket. They would not, and I asked the court, I actually filed a motion in November of 2018 requesting the court order the department to pay for her to go there, and they refused. The only thing the department offered in all of 2019 is if she could find someone to drive her, they would reimburse that person the gas money, just the gas. Now, granted, for those trips down there, Mountain Youth Academy in Tennessee does offer to pay for the hotel for parents who want to come down and do therapy in person for a weekend. She managed to take advantage of that twice, but that was because of her ex's connections. He had a friend who he got to drive them down there. Well, that didn't help her with staying away from him, because the only way she got to go in January and May was because his friend agreed to take both of them, and they took advantage of the free hotel so that they could see their son. That's all the department would do. We asked repeatedly for assistance about getting a cell phone. And then they said, well, you only get one free cell phone and you already used that, so we can't get you another cell phone. We can't help you pay for minutes. We can't set up a time so you can participate in counseling. All of these are things that when Mom did show up for MDTs, and she did miss some, because like I said, she did have positive drug screens, so she did drop in and out of contact with me and with the department, and sometimes she showed up for some drug screens, sometimes she didn't. She switched from Chestnut Ridge to Roots and Harmony because she thought it was closer to her home and she'd be able to get there. I never did get drug screens from them. I tried. They still, to this day, have not sent me those records.
Okay. I'm going to have to interrupt. I'm sorry. First, we have to have additional case to do so today, and I believe you've answered Justice Walker's questions. So I'll ask you to please conclude your comments.
Oh, just a closing statement?
Well, if you have anything else to add, I think we understand your argument. And
The only other thing that I would add sort of also goes to that. The court was against post-termination visitation. They insisted on terminating her parental rights, and they insisted that they would not allow visitation at all. I wasn't even sure you guys would consider this or how serious you might take it, and I was trying to pressure my client into doing an inpatient drug treatment, so I offered that if she did that, I would file a motion to get her post-termination visitation. She didn't do inpatient.
I believe you are getting into something other than rebuttal, so I'm going to ask, I appreciate your argument and appreciate all the arguments of both parties, and this case will be submitted. Thank you.
Thank you.
The next case for oral argument is State of West Virginia versus David L. Ingram, docket number 190016. This case is on appeal from the Circuit Court of Fayette County, West Virginia. Counsel, I will let you know that although Justice Workman isn't here with us today, she is participating, she's viewing and listening, and she will be part of the decision and opinion in this case. I'll remind you that under Rule 19, you each have 10 minutes to present your argument, and we have put a clock right there by the podium that the two of you will notice is an addition since the last time you were here. So, counsel for the petitioner, you may proceed.
Thank you.
Just so you know, we have removed our mask because we are socially distant. If you wish to remove your mask during the argument, you may. You may not wish to, and that's okay too. But
all right. Thank you, Your Honor.
Certainly up to you.
May it please the court, my name is Matthew Brumman with Public Defender Services, and I'm here today on behalf of the petitioner, David Ingram. Petitioner in this case sold a truly minuscule quantity of drugs to a confidential informant. Police arranged for the solicitation by the CI, monitored the transaction from beginning to end, and intercepted the drugs before there was an opportunity for them to harm anyone. Especially under this court's recent decision in State v. Hoyle, this is insufficient to justify a life sentence in prison. And it's insufficient for two reasons. First, the distribution of cocaine itself and methamphetamine was factually nonviolent. And two, petitioner's only violent predicate, which occurred over 20 years ago, is too remote to justify a life sentence. First, this court recently decided State v. Lane, in which it found that the delivery of oxycodone to be nonviolent on the facts of that case. The drugs at issue in this case are categorized exactly the same way by the legislature. They're both Schedule II narcotics. They subject the defendant to the exact same penalties under the statute, and the state had to prove the exact same elements in this case as they did in Lane. Furthermore, this isn't an arbitrary distinction drawn by the legislature. It's their prerogative to make decisions on policy, and they've decided to categorize these drugs differently from the heroin, for example, at issue in State v. Norwood, because there is some legitimate trade in the United States. And as a Schedule II narcotic, both methamphetamine and cocaine fall into that category. Obviously not as frequently as hydrocodone, but that probably says more about the distribution of hydrocodone in this country than anything else. Second, another factual distinction that I think may be even more important between Lane and Norwood, the sale in this case is exactly like the one, is much more similar to the one in Lane than it is to Norwood. In Lane, you had a confidential informant that approached a known drug house where everyone present was using, sharing, selling drugs amongst themselves, and the CI made a purchase there. Compare that to Norwood, where instead of having mutual addicts sharing their supply, you had an established professional drug dealer. In Norwood, the drug dealer showed up with a large quantity of heroin, portioned off a small amount based on what the CI could afford, and individually packaged it for them. Petitioner's case is much closer to Lane. Petitioner showed up not with a large quantity of drugs to the methamphetamine sale, this is the only one we have a video of, but rather a small baggie that looks to be for individual consumption. He opens this baggie for the first time and removes a small portion of that single usage dose to give to the CI. And he doesn't even have the ability to repackage it for her. He gives it to her in her hand and she had to package it later herself. That's not the actions of a professional drug dealer. We also know that he didn't even package the methamphetamine himself, because when he opened that package for the first time, he was surprised to find, in addition to methamphetamine, a pill that he believed to be Ritalin. My client does not use Ritalin. He has no use for Ritalin. And he didn't even, and so he just gave it to the CI because she did like Ritalin. He just gifted it to her. This is not the action of a professional drug dealer like we have in Norwood. We have this pattern that we see a lot in rural West Virginia where users, mutual addicts, share amongst themselves. They're selling, of course, but it's simply an issue of who's holding when. If this transaction had happened 2 weeks earlier or 2 weeks later, it's very possible my client would have been going to the CI to buy, not to sell.
What effect does Senate Bill 765, which became effective June 5th of 2020, what effect does that statute have upon what you're talking about today?
Well, my personal opinion is probably not very much, Your Honor. There was nothing wrong facially with the old version of the statute. It's always been an as-applied challenge. So I think that unless this court wants to revisit that and say that the legislature's speaking to that issue helps solve those problems, there's still going to be room for as-applied challenges.
Does the fact that that case was passed, does that raise any issues with regard to the sentencing, i.e. would your client have the ability to say, oh, wait a minute, I want to go under the new statute?
I don't believe so. My memory of the West Virginia Savings Clause is that it's cut off at sentencing. If the new statute had gone into effect before he had been sentenced, then he would have had the option to proceed under that. But sentencing is the cutoff, if I remember correctly.
Under the new statute, though, what, as I read it, what your client would have, or was convicted of, would have subjected him to enhancement, right?
Well, I mean, that is an interesting idea. This court could, but yes, the new statute does say that pretty much any sale of a drug counts as a qualifying offense.
It schedules. I mean, it talks about Schedule 1 and Schedule 2. This new statute does, doesn't it?
Yes, and I believe that this sale, if I remember correctly, this sale would qualify under the new statute, and that's kind of an interesting idea to look to the new statute for the legislature's impression on what is and is not proportionate. But I think we should take that to its logical end, Your Honor. The new statute also says that you cannot use as a qualifying offense anything that happened more than 20 years ago. And the only violent crime in my client's past, the second-degree robbery, happened over 20 years ago. So if we're looking to the new statute for guidance, then that's too remote to be used. So if, under that theory, the current one is violent, but the old one doesn't even qualify to be used in a recidivist at all.
So if we look at Lane was 2 oxy pills, and Norwood was heroin.
Yes.
And this case is cocaine and meth.
Yes.
And you've spent understandably an appropriate amount of time talking about the circumstances of the drug deal, the quantities, but while we came to different conclusions in Lane and Norwood, and as in the briefs here, seeking some clarity from this court, and as Justice Hutchison referenced, the legislature has attempted to enumerate 70-plus circumstances that the enhancement would be recognized. Don't you think that the cocaine and meth are more in line with a Norwood heroin circumstance rather than a Lane oxy situation?
I don't, Your Honor, for precisely the reasons I stated. First, it's the same schedule, the same type of drug that this court addressed in Lane. It's not legislatively treated any differently. And second, the nature of the sale itself, I think, should weigh on this court. When you've got a professional drug dealer with a large quantity of drugs at a drug sale, the stakes are much higher. He's got more drugs at stake. He may be carrying more money on himself, him or herself, and frankly, they may be answering to someone higher up the food chain than them. You don't have that situation in situations like this in Lane, where it's addicts basically mutually sharing amongst themselves. My client had a very small quantity of drugs on his person. The same way I'm less likely to fight back against a mugger if I've got $1,000 in my wallet versus 10. That lowers the stakes of these transactions. It's also lowered by the fact that these are neighbors and acquaintances who know one another. It's a very different situation than the prototypical drug sale we think of. This isn't The Wire. And so because of that, there's a much less of a chance of violence in that situation. This court adopted State v. Hoyle specifically to bring some consistency and predictability to the law of proportionality. And I think that this case is just far too similar to Lane to justify any different outcome. You've got the exact same triggering offense. The drug itself is different, but the state had to prove exactly the same elements. The legislature categorized these drugs exactly the same way as the ones in Lane. And the sale itself, as I said, does not speak to violence. But it's more than just the triggering offense. The predicates, too, are very similar to Lane. In both cases, you have a nonviolent predicate for the most recent one. In my client's case, it was an attempted shoplifting that they used to elevate this to a life sentence. There's no question based on the elements, the nature of the offense categorically, or any other method that this court wants to look at it to conclude that shoplifting or attempted shoplifting is a violent offense worthy of a life sentence. The same as in Lane. Also the same as in Lane, the remote predicate is the only one that shows any history of violence. Obviously this triggers the second factor in State v. Hoyle. Second-degree robbery requires a threat of violence. But this court was not bothered by that in Lane because of how old it was. Not because of its age per se, but because a violent offense almost 2 decades ago, followed by 2 nonviolent offenses, did not show any sort of escalation or pattern or tendency towards violence.
Counsel, I believe your time is pretty much up, so if you would conclude your comments.
Thank you, Your Honor.
From the respondent, please.
May it please the court, my name is Gordon Mowen on behalf of the state of West Virginia. Petitioner's life sentence in this case is constitutional. The test under which this claim is evaluated is well-established, Syllabus Point 12 of State versus Hoyle. There's a three-part inquiry. It measures whether petitioner's criminal history includes 2 felony convictions that involve either violence, the threat of violence, or substantial harm to the victim. And the parties agree in this case that petitioner has at least one qualifying offense. That is his conviction of non-aggravated robbery that had an element of violence. So we've got one qualifying offense. So then the question is simply, is there another qualifying offense out of petitioner's remaining 4 felony convictions? So there's quite a bit to pick from. The 2 underlying offenses in this case were trafficking in methamphetamine, trafficking in cocaine. Those are both felony offenses. Unlike in Lane, where the individual was involved in the sale of oxycodone, this case with cocaine and methamphetamine is more like Norwood, which involved the sale of heroin, which Your Honor recognized just a little earlier. It's certainly the state's position that cocaine and methamphetamine are far more like heroin, which in Norwood this court ruled justified imposition of a life sentence, as opposed to oxycodone, which in Lane this court rejected application of the life sentence. And the basis for that is pretty straightforward. Cocaine, like heroin, doesn't have any lawful purpose. It's illegal from the moment it's created. It is created clandestinely, which is what this court recognized with respect to heroin in Norwood. And then the same is true with methamphetamine. It has no lawful purpose. That's different, of course, than what this court recognized in Lane with oxycodone. You can get oxycodone. You can go and use that. That can be prescribed. You can use that under the direction of a doctor. You can't do that with heroin. You can't do that with cocaine. You can't do that with methamphetamine. And so in Norwood, this court said heroin is an inherently dangerous drug which justifies imposition of the life recidivist sentence. This court should say the exact same thing about cocaine and methamphetamine because for all intents and purposes, they're just as bad as heroin. Again, different from oxycodone, which in Lane this court said didn't present the same concerns that heroin has. So I believe the logical follow-through of these cases is this case is a Norwood case. This is not a Lane case. I have 2 additional pieces of authority for this court to support that position. So the first is State versus Hoyle, which is the most recent opinion that this court has authored addressing application of recidivist for drug offenses. So in Lane, this court, Justice Walker, writing for a majority of the court, distinguished Lane and Norwood. And just on precisely the same grounds that I just articulated. In Hoyle, this court said Norwood, heroin, inherently dangerous, justifies application of the recidivist statute. Again, according to the Hoyle court, Lane, oxycodone, doesn't present the same concerns. And so it's the same argument. Cocaine, methamphetamine, no legal purpose, always illegal. It's always nefarious to sell. It harms society. It is the same, it is equivalent to heroin, which according to the distinction drawn in Hoyle, supports application of the recidivist sentence. The second piece of authority I have for the court is a very recent memorandum decision issued on June 25th of this year, State versus Gaskins. And in State versus Gaskins, this court said that delivery of cocaine is a qualifying offense because the harm that such drug trafficking has on its victims justifies application of the recidivist sentence. So there is already authority to support the state's position that cocaine justifies imposition of a life, delivery of cocaine justifies imposition of the life recidivist sentence. Otherwise, I would briefly like to point out that Your Honor, the state would suggest that the legislature's inclusion of the Schedule I and Schedule II drugs in the new recidivist statute is indicative of the legislative policy that trafficking in these offenses is harmful to our society and justifies a severe penalty, which is the same, that legislative declaration is the same consideration that this court discussed in Norwood and Hoyle. So it's part and parcel of the same thing. So for these reasons, the state would ask that this court affirm petitioner's conviction. It is constitutional. Trafficking in cocaine, trafficking in methamphetamine are serious, serious offenses that harm society. They harm the victims. And so this court should affirm it.
I have a question real quick. I'm sorry. United States Supreme Court Johnson versus United States struck down language kind of like the language that we're talking about here, that where it says committed a felony that involves conduct that presents a serious potential risk of physical injury to another. And the Supreme Court struck that language down as being unconstitutionally vague. Do we have a problem here?
No, Your Honor. There's no problem here. First, because there's not been a vagueness challenge raised in this case. So that's not before the court here. If there was a constitutional issue with that language, there is a procedure under state law for that claim to be raised. Petitioner could file an original jurisdiction petition here under the court's habeas corpus authority, or it could institute habeas corpus proceedings in circuit court. So there's certainly an avenue there, but it hasn't been raised here, and so it shouldn't be addressed. The petitioner hasn't even asked the court, for instance, to invoke plain error, because it's just not part of the briefing. So that's my quickest answer to kind of cut the legs out from under that is that's not before the court today. In addition, my understanding of Johnson versus United States is that was language under the Armed Career Criminals Act of federal legislation, which is not this, obviously that's not the statute at issue here. And so there may be, because we've got case law developed, that is another distinction. And I would like to make a slightly finer point on that, which is the legislature hasn't said that crimes have to be violent, right? That language isn't in the statute itself, but that was the statutory language at issue in Johnson. This is a constitutional test created by this court in Beck and Wanstreet versus Bordenkircher, which looks outside of the text of the statute to evaluate whether it's a crime that comports with West Virginia's Constitution. And so we don't have to worry about ambiguity in a judicial opinion. That doesn't present the same constitutional concern as ambiguity in a legislative enactment. And so because our recidivist statute doesn't have that language, we will not have that problem that the Supreme Court faced in Johnson. And I think, Your Honor, that's my better answer, so I'd like to start with that one and finish on the first one.
Well, it's better to finish on a high note.
That's very true, very true. Thank you.
All right. If there are no further questions, thank you.
Thank you.
Thank you. Commissioner has a brief rebuttal.
Your Honors, there's quite a bit there I disagree with, but first and foremost, I don't think it's true that we agree that my client already has one qualifying offense. I certainly agree that second-degree robbery is a violent offense, but whether it qualifies here is another question entirely because of its remoteness. And if we look to the legislature's weighing in dialectically on what is a proportionate sentence for recidivist purposes, the legislature says that that second-degree robbery is too old to count for anything. If my client were tried under the new version of the statute, we wouldn't even be talking about whether distribution of cocaine is violent or not, because he would only have one prior felony for purposes of the recidivist statute. So to the extent that we can look to the new statute for guidance, I think that's an excellent idea, but I think we have to be more fair-minded than only looking at what the legislature considered to be qualifying offenses. We also have to look at the legislature's pronouncement on remoteness. Secondly, the state's distinction here that cocaine and methamphetamine have no legitimate use is mistaken, to be perfectly blunt. The whole reason it is a Category 2 drug is that you can legally, pharmaceutically manufacture cocaine and methamphetamine in this country. Cocaine is an infrequently used, but still nonetheless used, painkiller in dentistry. Methamphetamine can be prescribed in extreme cases of ADHD, and I mean methamphetamine, not just amphetamine. Those are legitimate uses that are recognized by the legislature. That's the whole reason they're Category 2 drugs. I think hydrocodone is certainly prescribed more frequently as a Schedule 2 drug, but I think that speaks to problems with hydrocodone distribution more so than anything else.
You used to be able to get cocaine by buying a Coke.
You used to be able to do that too.
Or a Pepsi. So.
Now you have to go to your dentist, Your Honor. But this idea that it's just as bad of a drug, I don't think bears out based on the legislature's categorization of this as a Schedule II drug. The legislature has primary control over, primary prerogative when it comes to policy, and they've seen fit to separate out cocaine and methamphetamine because of their legitimate uses to be like hydrocodone. It's the exact same elements that the state had to prove in Lane as they had to prove here. So as far legislatively speaking, they're the same crime basically. Moving to Gaskins, I think that this really gets at a problem with the practical nature of proportionality analysis. Ultimately, what you're looking at in proportionality is the fairness of a life sentence. And in an ideal world, we would look at the defendant's entire conduct to figure that out. But as a practical matter, we only know the facts underlying the triggering offense because we just had a trial on that. As a practical matter, we don't know anything about the underlying cases other than the fact of conviction. And so we have to look, we can only look at the elements and the nature and the history of those offenses rather than the defendant's actual conduct. And that was the situation in Gaskin. This court found that in the abstract, it's possible for cocaine to carry enough violence that if there is a sufficiently violent triggering offense, that it would justify a life sentence. But that's not this situation. This is the situation like Lane, where the distribution is the triggering offense. We know the facts. We know what happened. We know that these were two mutual addicts sharing amongst themselves. We know that there was hardly any drugs present during the drug transaction. We know that that the stakes were much lower than in the Norwood situation, where you had a large quantity of drugs. And my client didn't even have the ability to really sub-package. When he broke up that one individual dosage and split it in half basically between him and the CI, he didn't even have the ability to give it to her in a package. She had to take it in hand and package it herself later. That's not the action of a drug dealer. That's not the action of someone as a defendant such as in Norwood. That's in line with Lane.
Any other questions?
No.
Nope.
I'll very briefly conclude, Your Honor, and just say that ultimately the question is whether a life sentence is fair or not. And there's no factor that should weigh more heavily on what the defendant deserves than what the defendant did. We know what kind of transaction this was. We know it was like Lane. We don't need to approve of the drug trade or condone my client's actions to realize that a life sentence is unfair based on selling such a minuscule quantity of drugs. Thank you.
All right. Thank you. You are argued. Thank you. This case will be submitted.
Thank you all.
Thank you. Good arguments on both sides.
Yep.
Thank you. Thank you. Thank you.